Our second case scheduled for oral argument this afternoon is Ray Jordan Lane versus City of St. Petersburg and Commercial Risk Management, Inc. Is council ready to proceed? Council, we've allocated 15 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
Yes, please, 3 minutes.
So noted. You may continue, counsel.
May it please the court, my name is Nicolette Sambus and I represent Ray Lane, the appellant and claimant in this matter. This case turns on a simple legal error. The burden of proof was placed on the wrong party. Standard of review, as we stated in our briefs, is de novo review because it involves strictly a question of law. There's very little questions of fact that are in dispute. The claimant was involved in a work-related accident that occurred in February 2022, February 21st, 2022. He was provided work-related benefits, including medical care, a significant amount of medical care, and lost wages.
And you're referring to the burden of proof on the issue of unless the carrier can establish material facts relevant to the issue of compensability, it could have not been discovered through a reasonable investigation within 120 days, correct?
That's right. Florida Statute 440-20 states that the burden, it's that quote that you just said, the carrier shall immediately and in good faith investigate. Then it continues on, shall admit or deny compensability within 120 days. If the carrier fails to deny compensability, it waives the right to do so, unless it, meaning the employer carrier, can state relevant material facts regarding compensability that could not reasonably have been discovered within that 120-day period.
So I'm looking at Churchill,
Yes.
and I'm wondering why we even get here. Churchill laid out the rubric for this, that when a claim is made, a workers' comp claim is made, that the carrier, and I'm not sure if we have a carrier here because it's self-insurance, but that's a different issue we'll talk about later, that the carrier has the option of they can pay and not contest, and they basically have waived compensability, or they can deny. And then if they're held to have wrongly denied, they've got attorney's fees and all that rolled in there. So they don't want to do that unless they feel certain about it. But 440.20 creates a situation where they can pay and investigate.
That's right.
But to trigger the pay and investigate, under Churchill, it says they have to send a 120-day letter saying, hey, we are invoking our right to pay and investigate. That was never done, right? There was never a 120-day letter.
That's correct. Well, there's no evidence that there was one.
They've foregone their opportunity to avail themselves of 440.20, right?
Right.
And so they paid without preserving the right to investigate and deny later. So why not under Churchill? It seems to me that we really shouldn't be talking about whether this information could have been discovered or should have been discovered.
That's right.
Okay? So why are we talking about that?
Well, we're talking about it because the judge finds that Churchill relies on Dunleavy, and says that they didn't have the information, so they're excused. So this is a case where we have a compensable accident because they accepted it, right? They paid. Throughout the answer brief, they acknowledge that they treated this. The adjuster testifies that they accepted this accident as compensable. We're talking about 440.20 because they waived their right to deny compensability. Just because they didn't send the letter under Churchill doesn't mean that that waiver doesn't apply. That's the point of what I'm talking about, is that the judge says Churchill doesn't apply. They denied it within a reasonable period of time after they became aware of the
2 years later.
2+ years later, Your Honor. And that's the problem that we have here, is that 440.20.
In Churchill, our court said that they had waited too long when they sent the 120-day letter within the actual 120 days. I forget the exact time, but it was before the 120 days were up. They sent a 120-day letter.
They sent the letter 59 days later, I believe, or around that period of time.
Absolutely correct.
So
59 days later, and our court said no. You have not invoked your your opportunity to pay and investigate.
It-
You've waived, and they remanded, and they said, okay, JCC, we're remanding this to you, and compensability has been established, and you can just go forward and discuss the other parts of this case, right?
Right. Your Honor, that's the error here, is that this is a case that was compensable. Waiver has been, the ship has sailed, so to speak. 2.5 years later, the law and the legislator's intention is to protect the injured workers from exactly what has happened in this situation, where the employer carrier gets this.
Counsel, the statute has an exception to the ship having sailed, dealing with waives the right to deny compensability unless the carrier can establish material facts relevant to the issue of compensability that it could not have discovered through reasonable investigation within the 120-day period.
That's
Is that
right.
correct? Was that established in this case?
No, Your Honor.
And why not?
And you'll see in the record that the record is absolutely void of any judicial findings that this evidence could not have been reasonably discovered. That's the point here, is that there are several cases that
Well, they say that there was nothing in the record that put them on notice that they should look into that.
That's funny. So let's talk about that, right?
Okay.
What do we have in the record that says that there was a deviation? We have the accident location that was immediately available in the police report. We have Mr. Bates's testimony, who is the claimant's supervisor, the person that he is supposed to report his work accident to, that was there on the scene, that wrote the claimant up. There is the written disciplinary notice that was given to the claimant on July 22nd, 2022. It was written the day after the accident, but it wasn't given to him until July 22nd,
But you have
2022.
Mr. Bates' deposition testimony and Mr. Marks' live testimony,
Yes.
correct?
Yes.
Yeah. The JCC credited Mr. Marks' testimony over that of Mr. Bates' testimony.
Yes.
Is that a credibility determination?
That is a credibility determination, but that doesn't change the question of law here that exists,
How
because
do we get around that? Let's assume we agree with you. Let's assume we agree with your argument. How do we get around that determination by the JCC?
yes, Your Honor. So the case law, there are several cases that we cite in our brief, Winston, Boyette, Sierra, Paradise, they all talk about that it's the JCC failed to state why they didn't depose the witnesses, why they didn't review the records in time, why one case is about the MRI reviewing on time. The reason why this doesn't matter between the credibility of Marks and Bates is that the evidence was there, and the judge fails, and the record is void of any explanation as to why they didn't reasonably investigate it. The employer is the carrier. There is no severability between the employer and the carrier, and we talk about that. Notice to the
Because it's not a
employer.
carrier.
Well,
It's-
right.
It's not, they self-insure and they use a third-party administrator, right?
So, but they're resting on the premise that they're two separate people, but they're not two separate people.
Right.
They
Mr.
are.
Bates knew, Mr. Davis knew, Mr. Alexander knew.
Mr. Howard knew, who was the
Everybody knew
coworker.
except for the person that it was their job to know.
Allegedly didn't
Allegedly.
know. Right.
He said he didn't, but all the supervisors said, yeah, we told Mark.
And he was written up for it. He was written up for it. The employer file is
But
clear.
counsel, the JCC referenced commercial risk management throughout the order
Yes.
as the carrier, Now, I understand the legal argument, though. Was that legal argument made below that the city of St. Petersburg and commercial risk management was not a carrier as defined by Chapter 444 of the statutes? That's the question.
No, Your Honor, that wasn't the focus, because that doesn't need to be the focus. The issue is that they are one, regardless of whether you define them as a carrier or a servicing agency. Notice to the employer is notice to the carrier or the servicing agency or the one lumped together, because you see it throughout Chapter 440. There's 440.185.2, we cite in our brief, 440.41. 440.41 is really particular. Notice to or knowledge of an employer of the occurrence of an injury shall be notice to or knowledge to the carrier. This includes why, where, when it occurred. That's this accident. The Gomez Lawn Service case from 2022 talks about the employer's failure. That was where the employer is the injured worker, and that does not mean that the carrier can sit back and say, oh, well, we didn't know about it because the employer didn't tell us. And that's what essentially the employer carrier's answer brief tries to do. They try to claim that on page 12 of their answer brief, it says, even if notice existed earlier at the employer level, the carrier cannot be charged with knowledge it did not timely receive. Well, that's interesting to say. I mean, if you apply that to any concept in workers' comp, that just automatically gives the servicing agent or the carrier just the right to sit back and be like, well, the claimant gets screwed here because the employer didn't tell us about it, and we get to now waive a deviation to employment 2.5 years later after this man has received a significant amount of medical care, a significant amount of lost wages.
In the absence of Mr. Marks' testimony, would notice to Mr. Bates have been sufficient in terms of deviation?
Yeah, well, there's more. There's more than just notice to Mr. Bates. There's where the accident happened. There's his write-up that happened. There's the fact that it's in his employment file, and then he was subsequently laid off or terminated from the employer because the 90 days ran. So it's interesting to note that the carrier, servicing agent or carrier claimed that they knew he was laid off, and they stopped his indemnity benefits or changed his indemnity benefits, and that's in the employment file, along with the notice of discipline. And yet now they claim 2.5 years later, when all of a sudden they've already started paying, and now they look for a reason to stop it. The standard is not whether the carrier did not know. The issue is once benefits were paid, they must be paid at the proper rate, and the exception does not apply. The claimant or the employer carrier cannot be rewarded because of their failure to investigate. I want to touch.
The statute, they say in the order that they didn't know. How were they supposed to know? But the standard is whether the information could not have been discovered through reasonable investigation.
Right.
And it seems here, and all the cases refer to the pay and investigate.
Right.
There was no investigation. Seems like this could have been something that one phone call could have cleared up.
They didn't talk to anybody, Your Honor. They didn't ask any questions, and it's 2.5 years later, and then it's even 740 days after the disciplinary notice. You'll see the disciplinary notice on page 23 of the record where the judge cites it, and then again at 685. In the disciplinary says, Mr. Lane later admitted to his supervisor that he was not performing work duties at the time, but instead was headed home.
By the way, you're in your rebuttal time.
I know, but I got to touch on
We're
point
gonna
number
spend the
2.
rebuttal time and view all
Because
these-
point
all
number
the
2 is
questions we
really
have.
great.
No question about that. You may continue, counsel.
Okay, well, point number 2, just quickly, I think that's pretty self-explanatory. The Mathis case controls here. Even if you were to assume that my point 1 does not get reversed, which it should, the claimant was receiving lost wages that were being reduced at 25% based on the alleged seatbelt violation. The judge found in her order that the claimant was wearing his seatbelt. All the testimony, there's nothing to contradict it. She makes that finding. So according to Mathis, you have to pay the benefits at the proper rate up until the date of the denial. So even if the denial stands, which is July 2024, all benefits paid prior must be paid. And that means that he needs to be reimbursed that 25% reduction that happened. So the first point of appeal needs to be reversed based on the burden of proof not being appropriate, that the carrier already accepted it. And then point number 2, even putting that aside, the 2 issues are independently reversible based on the case law. Thank you, Your Honor.
Before you sit down,
Okay, I can keep going.
the JCC found the Dunleavy case instructive here in support of her ruling. Can you distinguish the Dunleavy case from this case?
Easily, Your Honor. Dunleavy involved a firefighter who was allegedly involved in horseplay. There is no red flags in that case, and that's what the term was, red flags. The supervisor did not know. The employer did not know. It was a claimant and a coworker. He injured himself when he was getting up. went to the hospital, and the claim was accepted. That involved a significant delay as well, Your Honor, but in the record, in the facts that were before this court, it was clear there were no red flags. Here, there are numerous red flags. Mr. Bates' testimony, the claimant's direct supervisor had notice. Claimant was written up by the employer with the disciplinary notes in the file. The adjuster notes even state that she started working on the claim in February 2022. In her notes, it says, investigated demographics, accident details, and pre-existing history. That's page 471 and 472 of the record. That is clearly distinguishable from what we have here. And I think it's more similar to the Boyette decision, which is the hernia decision from this court, where the denial of the case came 300 days later, and this court noted that the employer, and they distinguish. In this court wrote, employer received written notice of a fellow coworker 11 days later that the man was complaining of a hernia, and that states employer notice. It doesn't say employer carrier. And that one was determined that that compensability was waived, and the employer carrier should have accepted the claim. I'm sorry I went over.
That's okay. We're going to extend your rebuttal time by 4 minutes. And we'll extend counsel to our police time by an additional 4 minutes. If needed.
May it please the court, my name is Kimberly Pirano from Jones, Hurley & Hand, and I represent the employer servicing agent, City of St. Petersburg, and Commercial Risk Management. This is not a waiver case. This is an undisclosed material fact case. Section 44020, paragraph 4 contains a material facts exception. The statute is not disputed. The only dispute is factual. Whether the carrier could have, or servicing agent could have.
What of the failure to send the 120-day letter? Because in Churchill, they said, because you didn't send the 120-day letter, we don't even have to get into what the facts that weren't disclosed.
Well, this was a case that was paid. This was not something at the time when the case was first sent and the report of injury was sent.
Churchill was paid for a period, and then they sent a late 120-day letter, and our court said, no, you have to send the 120-day letter at the beginning. You can't wait till you're the end and then send it and vote.
Well, and that's where it goes into the statute where it says unless the carrier can show that there was the material facts.
Yes.
Well, it's material facts that could not have been discovered within 120 days.
Yes.
And that's the key issue here is the material
procedure.
fact.
The 120-day procedure was never invoked here.
Well, consistent with Dunleavy indicated that as far as the material facts exception, they said you didn't need to even go there because there was nothing that raised any reason to doubt the compensability. And
There was nothing in Dunleavy that the injured employee notified his employer that he was injured because of horseplay. Is that correct? There's no record evidence at all in Dunleavy of that.
He said he was hurt on the job. He didn't say
he
you
said,
were hurt
yes,
wrestling.
correct, but that information was not relayed to the servicing
But in
agent
this case,
until
Mr. Bates,
1 year
the immediate
later.
supervisor indicated that that information was related to him about the employee deviating.
Right, but Mr. Bates never relayed that information to the adjuster. In fact,
Mr. Bates said he did.
well, that was a credibility finding because
Is it really?
Mr. Bates, because Judge Young, looked at Mr. Bates' testimony and compared it to Mr. Marks's testimony, who is the work comp liaison between the sanitation department and the adjuster. And she found that his testimony that was live was more credible. And he specifically testified that the only thing he knew at the time of when the accident was in play was that it was a rollover accident.
But it was more credible solely because one witness testified via deposition, another witness testified at trial. Was there any other reason?
She did, yes, in
What
her
was the other
order.
reason?
She said that she found that Mr. Marks's testimony was candid, forthright, and he went through the timing of when he found out about the deviation. And that's where it's really, the focus is on the deviation, is when the appellant, they argue that, oh, there was all these records that were
Well, the
in.
entire chain of command knew about the deviation, right? And what distinguishes this case from Dunleavy Is in Dunleavy, nobody in the chain of command knew about the deed.
Well, we don't know that because it says just the chief then finally reported it a year later to the self-insured, to the adjuster in that case.
But in a case like this where the employer is actually the insurer and the managers of that employer who is also the insurer know about the deviation, it seems to me that the people that were paying the claim knew about the deviation, paid it anyways.
Well, respectfully, the judge made a factual finding that Mr. Marks was the sole liaison between the city of St. Petersburg and commercial risk management. And there was no reason, and it goes back to whether or not the carrier servicing agent had any reason to doubt compensability of the claim, and it's consistent with what the Dunleavy's finding is
So what
that.
investigation did the carrier servicing agent do? Because
So
it's called
it
paying
is-
investigated. Was there any investigation? Because this seems like a pretty easy thing to ferret out.
This was a case that was paid because based on, and this is a finding that the judge found, and it's consistent with Dunleavy, that there was nothing in the employer communications she had, the claimant's communications, and it's even in her adjuster notes, the investigation that she took, or in the medical records that indicated that there was any type of deviation. The accident reports that she received, and even the police report does not say the route, the assigned route that the claimant was on. All it says is that the location of the accident.
So all these people knew, but Mr. Marks did not know.
It's not by what they knew, it's but what was
No,
about the
all these
carrier,
people
but
knew,
what would
Mr.
be,
Marks did not know. Can we agree on that?
they knew, yes.
Yes, okay. And Mr. Marks did not know.
And
And
the,
Mr. Marks is the sole point of contact between the servicing agent and the city, right?
that's correct.
That is correct.
And it goes by
And
again,
did the servicing agent, adjuster, or whatever you call her, did she call Mr. Marks and say, tell me about this accident? Where did
yes,
it
so
happen?
there were communications with and she calls it the department head, Mr. Marks, and she had even testified that there was no indication the claim wasn't compensable at the time. It wasn't until July 18th of 2024 that she obtained that information. That's similar to Dunleavy, where it was over a year later that the servicing agent obtained the information regarding the horseplay that would go to the compensability. So it goes to the focus on is there anything that would have raised doubt at the time within the 120 days to have a reasonable investigation? And Judge Young found, and she made specific findings, that no, consistent with Dunleavy, there was,
The statute doesn't say that the standard is whether there's anything in the file that should have raised doubt. It says could not have been discovered through reasonable investigation.
right, and reasonable investigation, that is a factual finding from the judge.
And what was the reasonable investigation in this case?
The reasonable investigation was her contact with the employer, her contact with the claimant. She had, there was nowhere where the claimant even disclosed that, oh, I was going home off route. There was no mention from anyone from the employer about this off-route deviation until July 18th of 2024. So, and that's even mentioned in Judge Young's orders that there was an investigation. And again, with carriers,
Then it's
the investigation
reasonable
just
that
has to be reasonable,
under
not
these circumstances,
exhaustive.
It would have at least talked to the employee, and the
She
employee
did-
supervisor?
Excuse me?
Doesn't it seem reasonable that you would have talked to the employee as well as the employee's immediate supervisor as part of the investigation?
Well, again, it goes to, as far as the investigation and what was reasonable, that is the judge's determination that should have deference, because she made that finding in saying that there was nothing that was in the record for the adjuster, and it goes by what was in the carrier's file.
Was there any, I mean, concerning the location of the vehicle at the time of the accident, shouldn't that have been some notice that the vehicle was not where it should have been?
Well, I think the focus is on is whether that would have raised any doubt. At the point of what the adjuster, the carrier had in their file.
Or ask someone, was Mr. Lane subject to any discipline any time in the past 2 years? Or was he subject to discipline for this accident?
Well, this was a case that was paid because there was nothing at the point, and I think that goes to, a policy that you're not supposed to disbelieve claimants.
Yeah.
You're not supposed to disbelieve reports of injury unless there's some kind of red flag. And here, there was no red flag until July 18th of 2024, when it was disclosed that he was on an off-route deviation.
You're not supposed to dispute the claimant. Shouldn't there have been some conversation with the claimant?
There were multiple conversations with the claimant, but the deviation was never disclosed. What the adjuster had to rely on was the police report that showed that, and the report of injury that said that this arise within the course and scope of the employment and that he was driving a truck. There was no disclosure of any type of route or whatever deviation. And again, that was a factual finding from the judge that should be reviewed by competent substantial evidence.
I have a question about what caused the truck to wreck. It was a mechanical failure, according to the record?
That's
Does
correct.
that help your client any? But is there an argument that this mechanical failure would have happened if he was on his route?
Exactly. So, and that's the thing.
Preceding intervening cause, kind of an argument.
Well, and for Mr. Marks, he was the safety investigator, and he is the sole contact between
Investigator.
For the safety, yes. And on top of that, like for safety investigations, but he doesn't go by routes, and even testified he wouldn't be privy to that information of what route a person is assigned unless the supervisor tells him. He goes in.
Seems like the people in this case that are supposed to know the information were remarkably incurious about what happened in this accident.
I think it's a separate department with separate focus, right? There's in the department a disciplinary notice that isn't even in the carrier's file and not something that she would be privy to. It shouldn't be, and again, it shouldn't be, this section was never meant to punish carriers who are paying claims in good faith. And this was a case that you had a truck driver, he was in his uniform, and he had an accident, while at work. There was nothing in the file that raised any red flags, and I think that is where the focus should be, is was there any red flags? And again, that was Judge Young looked at based on the credibility findings in the facts that were in the record, that there was nothing that the adjuster could have reasonably discovered within 120 days about the substantial off-route deviation.
Most of these decided by depositions. Most of the evidence that we see are depositions that go before they take the deposition, and then they present that to the judge of compensation claims, right? Isn't that most of your cases? Isn't that how most of them work?
Not every case is in litigations. Some cases, and that's the thing.
From what I see, a lot of the evidence is by deposition. And I just worry that this case might set a precedent that as a practitioner, you would be a fool to submit the depositions now, because if the person who shows up live is automatically believed and the person on the paper is not believed,
well, it wasn't just that.
Change the case on both sides, how you're going to try cases?
Well, it's not just that he was live and one was by deposition. She looked at the testimony, specifically what Mr. Marks had testified as far as his timeline, and then she thought he was very thorough with the way that he had answered the questions with regards to when he knew about the substantial off-route deviation. And in addition, the express findings were that there was no information from the claimant, the employer, or physicians that raised doubt or uncertainty before July 2024, which is consistent with the Dunleavy case. The Boyette case is distinguishable. In that case, the court said that it involved emergency room records, and it was also the carrier was armed with their emergency room records and the witness statements. So Boyette is more of what was already in the carrier's file. This is an undisclosed material fact, the substantial deviation, that makes it different.
So did the claimant in this case, did he know that his payments were being reduced by 25% because he wasn't wearing his seatbelt? Because it doesn't seem like he did. Because it seems like at the time he said, no, I was wearing my seatbelt.
Right, that was And again, that was after the claim had already been paid. Like, this was, again,
Yeah, but
this,
they were paying him money over a period of 2.5 years, some odd 2.5 years. And they reduced the payment that he would have gotten had they understood he was wearing a seatbelt. They saw on like a police report.
right, but the police
a
report
reference
didn't
to an
say,
unrestrained person.
Correct.
But no one ever said to him saying, hey, we cut your benefit by 25% because you weren't wearing your seatbelt. Because it seems like if someone would have said that to him, he would have said, whoa, wait a second, we were hanging upside down in the truck. Of course we were wearing our seatbelts.
well, and the seatbelt is separate than the issue with regards to whether or not the carrier could have reasonably discovered he was off his route, which that's the material fact here within the 120 days. And the judge
Well,
found,
part of this case is whether he was wearing a seatbelt. And the judge, the JCC ended up finding out that he was wearing a seatbelt based on his
Right,
testimony.
yes.
Yeah. And his coworkers, because they remember hanging upside down in the truck and having to unbuckle and fall to the ceiling of the truck to get out.
okay, yes. But with regards to the main issue here, these are all findings. Like, she made that finding about the seatbelt reduction. Here, this is based on the testimony that she had from the adjuster. The adjuster even testified there was no indication in the claim when she had it that there was any thing to find that it was not compensable. And again, this is not something where, you know, at the time when a claim is being accepted, unless there is some red flag, the whole point and intent of Chapter 440 is for the prompt and efficient delivery of medical indemnity benefits. It's not for carriers to go looking for defenses to deny a claim when there is nothing in their file or any information that they could have reasonably obtained that would, you know, support denial. So, in closing, Judge Young credited Mark's testimony, found no facts triggered until July 18th, 2024, and the carrier denied promptly once the deviation was disclosed. Therefore, competent substantial evidence supports that finding, and the judge's order should be affirmed.
Before you sit down, counsel, I'm looking at paragraph 14 of JCC's order. And I guess during this safety issue that we're going to discuss, Mr. Marks states, at this time, Mr. Marks looked at the claimant, I guess JCC said, at this time, Mr. Marks looked at the claimant's route and determined that the claimant was 6 miles outside Route 21, his assigned route for that day, and about a mile from the yard. That fact alone seems like the information was there, that the claimant was outside of his route.
Right, but that didn't occur until July 18th of 2024.
As part of the investigation, wouldn't it seem logical to look at the route?
As far as his investigation at the time was just of the rollover accident, just indicating that it's a rollover accident. This was during a separate safety procedures investigation. And again, that is a factual determination that was made by the judge. And his testimony that this specifically didn't indicate any type of substantial deviation until this took place on July 18th of 2024.
Okay. I'm not sure what it says about looking at the routes. I assume the route reflects where you were at the time of the accident.
Well, the route is not where you were at the time of accident. The route is what was designated as a truck driver. They get certain routes every day.
Where he should have, he wasn't where he should have been. He was outside of his.
I mean, his route is where he picks up trash.
Right.
Right.
And that was some distance from the yard. So if he'd have gotten on the interstate and turned the other direction, he would have been heading to his route. And even though he was not on his route, he would have not been deviating, correct?
Well, he had a deviation. Like he,
No, if he had turned.
if he was on
if
his
he had
route,
turned
right.
in the direction of his route, even if he hadn't gotten to his route yet, he would not be deviating, right?
Right, because he's going on.
Because he
Yeah,
was going to his route.
exactly.
The point
exactly.
is, he would not have been 6 miles outside of his route.
Correct. Correct.
Before you sit down, I have one irrelevant factual question that I just have to have answered.
Okay.
Was it the iron or the boots?
Nobody knows. Thank you.
Thank you, counsel. Oh, you may continue, counsel.
I would just point out that it doesn't matter if it's the iron or the boots, right? So that's the point here, is that the carrier's whole argument claims lack of knowledge. Ignorance does not equal the inability to discover. That's the plain language of the statute. The plain language of the statute says unless it can show material relevant facts regarding compensability that could not reasonably have been discovered. That's the question of law. We shouldn't even be here because compensability was already accepted. So they don't have that right to reasonably investigate because they've already put the stamp on it. But now that we're here, they still didn't meet the burden of proof. I think an important case to look at is the Solsa case. And I'd like to just quickly point out Judge Kerr's concurring opinion because it's pretty interesting. I like how it's worded. It says it's not the 44020 is not a gotcha or technical claim. The law has now been around for 30 plus years. At the time it was 11. The law is intended to facilitate the administration management of work comp claims by employer carriers. For better or worse, 440-1928, which is the response to the petition for benefits, and 440-20 subsection 4, both contemplate that in some cases, benefits will be payable under circumstances where the merit of the situation might suggest otherwise. That was what the legislator intended. That is not what was accomplished in this case. The claimant was getting benefits for 2.5 years. He has relied on these benefits. There was no indication from the employer carrier at any time that his benefits were going to be denied. And then all of a sudden, somebody decides, well, we're paying way too much on this claim. Let's dig in a little deeper. And now the employer carrier gets rewarded for it. Like you pointed out, Judge Lewis, the deviation, the route, he went south when he should have gone north. That was there day one. That was present in the file. That was in the police report where it happened. That his job as a liaison was to investigate claims. She called him an investigator. I think that's important to point out. So the record is void. The judge of compensation claims order is void as to why these facts could not have been reasonably discovered. It's not that they didn't have them. Okay, I'll believe their story that they claim that they didn't know. But that doesn't change the fact that this claimant was denied benefits once they were paid. And 2.5 years later, they decided to change the plan. So I think the Solsa case is important. I think the facts of that case is relevant. In that case, it talks about the purpose of the legislator and the legislative intent behind it all. I believe it's also important to point out that here they indicate that they weren't privy to the disciplinary notice until July of 24. I find it hard to believe that. I mean, the word choice is interesting. Like they didn't have access to it. That's not the case. The employer and the carrier are one. They are joint. They have access to that information. So the fact that it was given to the claimant in July of 22, and then 720 days later, they claim they just found out about it, and they're going to start digging up things to try to take away all this claimant's benefits. He was getting psych care, orthopedic care. He was getting prescription medications. He was getting lost wages. So, Your Honor, based on what I have argued, I'm over my time. We ask that both issues be reversed.
And thank you, counsel, for your respectful oral arguments this afternoon. We stand adjourned.